Thanks very much. It's a pleasure to be here to talk to you about access to environmental information. Can everyone hear? Okay. I'm going to talk to you really from the perspective of an NGO which requests access to information very often. For those of you that don't know Client Earth, so we're an environmental NGO with perhaps our particularity is that the vast majority of our staff are lawyers, so we come at environmental protection from a very legal point of view. So I work in a very small team here in the Brussels office, and we work on implementing and enforcing the environmental procedural rights that are found in the Aarhus Convention. And I will talk more about that in just a sec. So I know that probably the vast majority of you are very well versed in Regulation 1049 and that we're going to hear a lot more about it over the next 2 days. So I really wanted to speak to you about what is specific about access to environmental information. Are there slightly different rules that come into play? What are they, and what difference does that make in practice for those who are requesting access to it and for those in the institutions who are treating those requests? But I just want to say at the outset that I'm not in particular advocating for a different set of rules for environmental information. As Giuseppe pointed out, I don't think that degrees of strict interpretations of the exceptions, depending on what kind of information you're talking about, are particularly helpful. And in my perfect world, Regulation 1049 would be interpreted in such an open way that we wouldn't really need to have recourse to the specific rules in the Aarhus Convention. But things are such as they are, and we often find that we do have to have recourse to them, and we do find that in doing that, that sometimes we can open up a little bit. We can make the institutions a bit more transparent across the board, even though perhaps at the beginning we were speaking specifically about environmental information. So first of all, the specific rules on access to environmental information are derived from the Aarhus Convention. So this is one of the only international environmental treaties that are actually legally binding. It's administered by the UN Economic Commission for Europe. Interestingly, this convention actually has a compliance mechanism, which means that members of the public can actually send complaints to it about non-compliance in any party member. So as you can see, there are 3 pillars of the Aarhus Convention: access to information, access to public participation in decision-making procedures that affect the environment, and access to justice in environmental matters. Here are the signatories. The EU is actually a signatory to the convention in its own right, which means that it applies equally to the EU institutions as it does to all of the public authorities in each of the parties. So you can see that it's, broadly speaking, the parties are pretty much the Council of Europe signatories, and that means that actually the way that the EU and its member states conducts itself in relation to this convention actually has a very important impact in the non-EU states that are signatories as well. So they can either kind of lead the way or sometimes provide an excuse for everyone to lag behind. So first of all, to understand the Aarhus Convention, it's important to understand why we have these rules. Usually, the EU and the member states, in their decision-making competence, they take decisions that affect people and they affect the subjective rights of people, whether it's kind of anti-discrimination laws or social employment laws or the right to make a profit and to conduct a business or consumer protection, etc. These really affect people's interests and their subjective rights. And that means that these people get together, they organise themselves, and they try to participate in these decision-making processes. And when a decision is taken that affects their rights, they can go to court to challenge those decisions. It's very obvious that obviously the environment and the elements of the environment can't actually organise themselves to do these things, so they rely on people to do it for them. However, the problem is that when people do it for them, quite often their subjective rights are not affected. They're acting in the public interest to preserve the environment for everyone and for future generations as well. And that, in many member states and in the EU, has affected their procedural rights to actually participate in decision making and to challenge decisions. And so that was why we had kind of needed supplementary rights for people defending the environment to be able to have access to these procedures. So that the Aarhus Convention is really kind of the legal expression of that concept in the EU. So the convention itself, its recitals are important because they recognise that every person has the right to live in an environment adequate to his health and well-being. And equally, they have a duty, individually and in association with others, to protect and improve the environment. So in order to kind of enjoy these rights and discharge this duty effectively, we need access to environmental information. So I just say that in my work, this really rings true in that a lot of what I do is supporting the lawyers working on specific environmental files, like be it the energy transition or marine biodiversity. I support them in having access to the information they need to participate in the decision-making processes that are ongoing and understanding where their input can be most effective, and understanding why perhaps the decision-making procedure has stalled or has taken an unexpected turn. And we also really try to get access to information that will allow us to help basically the work of enforcement authorities in enforcing environmental laws. That information is very difficult to get a hold of, which I'll explain to you later. So the Aarhus Convention, getting back to that, really recognises that having more transparent decision-making processes increases the accountability of the people making the decisions. This increases public awareness and support for the decisions, so it kind of increases legitimacy of environmental decisions, and it also means that the decisions, when they're taken, are better implemented and enforced. So it really leads to positive environmental outcomes. So these are kind of the legal provisions that we rely on in terms of having access to environmental information. I've spoken about the Aarhus Convention, and this has been implemented in EU law through Regulation 1049 in conjunction with Regulation 1367/2006, which was adopted specifically to take account of the Aarhus Convention. Whether it does or not is questionable. But in any case, these have to be read together when we talk about access to environmental information. There's also then a directive which also implements access to environmental information laws in the member states. So that's really the only area in terms of transparency in general where there's a kind of minimum harmonisation throughout the member states. So I don't really work at member state level. I very much work in terms of having access to the institutions, information held by the institutions. So that's what my focus is on today. But it's just to let you know that there's the directive really implements the wording of the Aarhus Convention very faithfully. So a lot of what I say in terms of the institutions will apply at member state level also. So obviously these specific rules I'm going to talk about only apply when in relation to environmental information. So what is that? So I kind of put that up there to show that it's a very wide definition, very detailed, but I'll just paraphrase it very quickly to say that basically it depends, the definition is really about what the information is about. So who holds the information, who authored the information, or what decision-making procedure it relates to is irrelevant to the question. If the information itself is environmental in nature, then the specific rules apply. And I say that because I find that a lot of, I come across in the institutions quite often that a kind of attitude that it's really only relevant to DG Environment, these rules, the Aarhus rules. That other DGs don't handle environmental information. So, for example, it's been really hard for me to convince DG Mari that information on fisheries control regulation is environmental information because it has a huge impact on marine biodiversity, but it's quite difficult to convince them of that. And this can make a real difference because, for example, there was a case, actually it's not listed in the folder, but I can give you the reference to it later because I don't know it off the top of my head. There was a case where Malta sued the Commission because the Commission had disclosed to Greenpeace information on fisheries controls. And there was a provision in the fishery control regulation on access to information that was that really went against what Regulation 1049 says. And so the court had to interpret these provisions and decide which one to give precedence to, basically. And very frustratingly for me as a bystander, because we don't have a right to intervene in cases between member states and the institutions, there was never one mention of the Aarhus Convention and of the fact that the information was environmental information. And I think it actually could have had quite it could have been very significant in terms of the outcome of the case, because the Aarhus Convention is a legally binding international treaty. There is an obligation to read Regulation 1049 in a way that can give effect to its provisions, and that didn't come up at all. So it's just to say that environmental information lurks in the most improbable places, simply because the environment is all around us and is affected by a lot of what we do. Are there specific rules when we talk about access to environmental information? So the Aarhus regulation says very clearly that when you do a request for access to environmental information, it is the provisions of Regulation 1049 that apply. So that means that it's the same time frames, it's the same confirmatory application mechanism that applies, etc., etc. However, there are some specific rules, and I'm going to go through them one by one. So first, there's a duty to interpret the grounds in a restrictive way. Secondly, there are really big differences that Päivi mentioned in terms of the way that the exceptions to access are worded between the Aarhus regulation and Regulation 1049 that really aren't taken into account very often by the institutions or by the court. Then, of course, there's the very important exception to the exception, which relates to information on emissions into the environment. So that means that when a piece of information relates to emissions into the environment, some of the exceptions just simply don't apply at all. And then there are specific provisions on active dissemination and on access to justice to challenge refusals. So I'm just going to take you through these. So first of all, the biggest addition to Regulation 1049, which the Aarhus rules give us, is Article 6.1. So this deals with, of course, the overriding public interest in disclosure of information related to emissions into the environment. I'm going to deal with that second. So first of all, I'm going to deal with kind of the general obligation, which is to read the grounds for refusal shall be interpreted in a restrictive way, taking into account the public interest served by disclosure and whether the information requested relates to emissions into the environment. So what does that mean in practice when you're actually trying to apply that provision? There's quite a lot of confusion, I think. Because, of course, we know from the court that all of the exceptions have to be interpreted strictly to Regulation 1049. So is there a kind of added, stricter standard when we come to environmental information? So, first of all, I just want to mention, let's see if I put it in the LPN Finland case. Sorry, I'm just going to deal with that first. Because first of all, we know that there is no practical implications of this provision when it comes to the exception that protects infringement proceedings. The court has ruled in that case that Article 6 of the Aarhus regulation simply doesn't apply to this exception. I think that's a very questionable interpretation of the regulation, to be honest, especially if you take into account the obligation to read it to conform with the Aarhus Convention. There's no real reason for it, but that is the situation that we're in just now, and it has huge implications for having access to any information on what member states are doing to implement EU environmental legislation. I'm going to come back to that later. But for the other exceptions, this second sentence of Article 6.1 really does apply. And we've seen that in two quite recent cases, at least two cases that came out since the last seminar 2 years ago. So the first one that I'll talk about is the Saint-Gobain case. I really like this judgment. One of the reasons is because a lot of people say when we are kind of pushing for more transparency that that's really not a good idea, because then industry will have access to more information as well, and they'll be able to use it much more effectively against the environment. But this is a really nice example of industry using the Aarhus regulation and creating a fantastic precedent that we can all rely on. So in this case it was Saint-Gobain were just trying to access information from the Commission on how the Commission had calculated its emissions allowances under the emissions trading scheme. And the Commission refused because it said, oh, this will really mean that we won't be able to, this will jeopardise the decision-making process, that if we have all of the companies then coming to us and giving us their views on how we're calculating their emissions allowances, then we just simply won't be able to take those decisions. And the General Court agreed with them, and the General Court even went so far as to say that actually this isn't a legislative procedure, this is an administrative procedure, and they kind of turned Regulation 1049 on its head and said, and therefore administrative procedures need more protection. Which isn't at all what Regulation 1049 says. So fortunately the Court of Justice on Appeal didn't agree with the General Court. And they said that it's not that the Article 4.3 that protects the decision-making procedure, it protects the decision-making, it doesn't protect an entire administrative process. And that they then turned to the fact that this was environmental information and said that it was really crucial that exception was applied strictly and not in the way that the General Court had put forward. And what's interesting is that then they actually looked for the first time at the wording of the corresponding provision in the Aarhus Convention, which protects the confidentiality of proceedings, to really show that in fact it wasn't the whole process that was protected. It was really the kind of decision-making part at the end of an administrative procedure. And so they reversed the General Court's decision. So then in the Klein-Terth case, this kind of stricter standard when it comes to environmental information was pushed forward, but in this case, it was on the impact assessment case that Paivi's already spoken quite a lot about. In this case, it concerned a general presumption of confidentiality, which is something that I dislike just as much as Paivi, especially in the context of environmental information. In this case, we had been following very closely. The Commission had published a roadmap putting forward its intention to put forward a proposal for a directive on access to justice and environmental matters at national level in the member states. And then they published the roadmap and nothing happened. The proposal was never forthcoming and we didn't know why and we didn't understand. But we knew that they'd been working on impact assessments. So we put in an access to documents request to have access to the impact assessments to find out what really was stalling the process and whether we could come up with a strategy to help unblock it. But the Commission refused, and applying a new general presumption of confidentiality to all of the documents involved in its core competence to introduce or to propose legislation. And again, it was the same arguments, saying that they couldn't possibly do this. They couldn't be independent if they were having to give out information on what was motivating their decisions. So again, luckily the court didn't agree with the general court's judgment, which had agreed with the Commission. And they said that when it comes to general presumptions, you have to show two things. First of all, that it has to be reasonably foreseeable that the protected interest would be harmed by disclosure of this whole category of documents, because of course it would then apply across the board to all of these documents. And secondly, it said that the general presumption has to be interpreted and applied strictly. And so when they looked at this specific criterion of whether it's being applied strictly, they took into account the fact that it was these were legislative documents, and B, that they contain environmental information. And they said that the court had not, that wasn't a strict interpretation of a general presumption, and they struck it down. So therefore, from these cases, my interpretation of what it means in practice to apply Article 6.1 of the Aarhus regulation when you receive a request for access is that you actually have to, in applying the exception strictly, it means that you have to get involved in a first weighing exercise. You have to weigh at this point the harm that's going to be caused by disclosure with the general public interest in disclosing it. And that's where I'm going to first talk about the Advocate General Hogan's recent opinion. And I don't know if many of you have read it, but for me it's a very controversial opinion, and it's about access to clinical trial information, and where he advocates for a general presumption and confidentiality. Putting that aside, he also deals with the question of when that weighing exercise between the public interest and a protected interest takes place. And he says that the General Court had applied it at that first initial stage in trying to decide on whether the exception applies at all, and that was wrong. The weighing exercise only comes into play after that. When you've decided that the exception applies, then you decide whether there's an overriding public interest. So I don't agree with his interpretation of that. One thing is clear is that the court's made it very clear that actually that weighing exercise that comes in at the end on the overriding public interest, it's not really the same thing. It's not about applying the exception strictly. It's when you've already decided that it applies. And also, the court's made it clear that really general considerations in terms of the public interest aren't relevant. It has to be very precise, overriding public interest. It has to be very pressing. So it's not about really the general good that can be done by the public having access to information on whether you're going to kill your dog, as Piney's example is. So that for me is really the clear point in Article 6.1 is that there's a first weighing exercise to be done about what is the general good in making certain information transparent. And it's very different from the overriding public interest test that comes at the end. That brings me to kind of the general problem of presumptions of confidentiality when it comes to access to environmental information and this weighing exercise that has to be done. I think it's very difficult to, on the basis of the Aarhus regulation, to say that there are huge categories of documents where it's very clear that it's not in the public interest to disclose them, or that the public interest is better served in not disclosing them. I think that decision should be taken on the basis of an individual concrete examination in every case. But anyway, the court has certainly confirmed that at the moment the state of play is that the institutions can apply general presumptions to environmental information. And I just want to give you an idea of the problems that poses for us, especially in the context of having access to information that could possibly be used in an infringement procedure. So that brings me to another case that we brought a few years previously where we wanted to have access to conformity checking studies. I don't know if you all know what that is. It's where the Commission basically pays consultants to look at whether specific directives have been transposed properly in the Member States. So this is kind of information that if we all had time and the interest, we could actually find out for ourselves. We can look at our own member states and see whether they have properly transposed specific pieces of legislation. But the Commission spends a lot of public money on having other people compile this information for them, and that's very good because it helps them to do their job more efficiently, and I certainly wouldn't criticise them for that. But the problem is that they refuse us access to it, and at first they did that on the basis of the general presumption of confidentiality that applies to documents that are involved in infringement proceedings. So we challenged that in court, and the court said that the general presumption can only be applied to conformity checking studies if they are already contained within the pre-litigation file for an infringement procedure. So that means that on the basis of the conformity checking study, the Commission has already decided to open an infringement procedure. Those studies are protected by the general presumption. So, okay, it was predictable. Then we went back with the decision, and we went back to the Commission and said, okay, well, we want you to implement this, and we want to have access to all the other conformity checking studies that aren't covered by this general presumption. And the Commission came back to us and said, well, the problem is that there's a huge number of studies that are either in a queue waiting to be assessed, or they have been assessed, but we just haven't got around to opening the infringement procedure yet. And you can't have access to any of them either, because it might potentially, down the line, in maybe a few years, jeopardise the infringement procedure that might be opened. So basically, they said we're not applying the general presumption because we are actually making this decision on the basis of having looked at the specific documents. But from our point of view, you might as well apply the general presumption because they apply exactly the same reason to all of these documents. So we took that to the Ombudsman, and the Ombudsman was, they're stuck. They've got some tricky case law to deal with. But they basically said that, as long as the Commission doesn't take too long in making that decision, that's okay. It's reasonable. It's very frustrating for us because we actually want to play a role in enforcing this legislation. A lot of public money has been spent gathering a lot of information that would help us to do it, and we just can't get access to any of it. The only studies that we did get access to are those that say that all of the directives have been transposed perfectly. So it's just to give an idea of the practical implications of these general presumptions. Just to go back to the Advocate General's opinion, it's very disappointing for us that he bases his decision on the court's judgment in our Client Earth case on impact assessments. He refers to the Client Earth test on general presumptions of confidentiality throughout. And on my reading, I don't think that he has applied that test correctly. I said it was a two-step test. The first, you have to show that it's reasonably foreseeable that the interest would be harmed by disclosure of that type of document, and he applies that part of the test. He applies it anyway. The second part, which says that you have to apply it strictly, is just completely ignored, in my opinion. There's no discussion of what such a strict interpretation and application of general presumption would mean in this context. So we'll certainly be watching this really closely, and if the court should agree with him, we'll certainly be making the case for that interpretation not to be applied to environmental information at the very least. So second of all, as I mentioned before, there are just some really big stark differences between the exceptions to access in the Aarhus Convention compared to Regulation 1049. I'm not going to go through them all in a lot of detail. I'll just maybe give you examples of some. So in Article 4.1 of Regulation 1049, the article that protects the interests on international relations, public security, etc., these are termed as an absolute exception in the regulation. The public authority has absolutely no choice on whether, if they apply, they cannot disclose the information. Whereas in the Aarhus Convention, it's not. These exceptions exist, but they're not absolute. There's still an element of discretion for the public authority to decide whether still, even though these very important interests come into play, it's still important to disclose the information. And that really is quite important, especially in terms of the environmental impacts of some of the international trade agreements that the Commission is negotiating and entering into, like TTIP and CETA, etc. Secondly, Aarhus says really specifically that commercial and industrial interests can only be protected by an exception if they are protected, and if those interests are protected in national law or in the EU law. And I think that overall this is interpreted quite well by the court, but sometimes not by the institutions. So, for example, we've had experience of requesting specific industry position papers that have been submitted to institutions, and they have not been disclosed on the basis that it would harm their commercial interests because it would be embarrassing to the company. And embarrassment is not really protected by law. To be honest, I don't think that would stand up to scrutiny in the court, so it's not something that I worry about too much. It's just frustrating. Then, of course, there's inspections and investigations. So in the Aarhus Convention, these are not protected at all, apart from when they are criminal or disciplinary in nature, because the whole point of that exception in Aarhus is about the equality of arms. Whereas, as we know, that within the context of Regulation 1049, inspections and investigations, particularly if they can potentially lead to infringement proceedings, are just, they have a whole other standard of protection that is not at all recognised in Aarhus. And I think that's a real problem. Then there's I kind of briefly touched on this when I talked about Saint-Gobain, about the decision-making procedure, that Aarhus protects the confidentiality of the proceedings, of the kind of deliberations of a public authority, and not the entire kind of decision-making procedure, which includes all the evidence that the decision is based on, etc. They're not protected under Aarhus. And there's a very good Advocate General's opinion in the Saint-Gobain case that really kind of talks about these differences and how they should be taken into account when interpreting the exceptions in Regulation 1049. I could see that the court had a tendency to agree with him in the actual decision, but they didn't go as far as the Advocate General opinion at all. But maybe in the future they'll have the chance to do that. And that brings me on to information on emissions into the environment, because this is the real exception to the exception, which is quite controversial because basically it means that some of the exceptions simply don't apply at all. So it really kind of trumps commercial interest, which is really a point of concern to a lot of companies, which I can understand why. The objective behind that, or the reason why there is this exception, is because of the notion that when a product or a chemical is emitted into the environment, it stops being the property of that company and it affects all of us equally, and therefore we should have the right to know the effects of the substance that's being emitted, and the effects it has on the environment in the long term, and the effects it has on our public health. So that's the reason for it being there. So this was quite a mystery, really. Actually, what the concept of information on emissions into the environment actually was a bit of a mystery until kind of November 2016, when there was case law which really gave a lot more clarity on what it meant. People used to think that it meant just it was really information on what was emitted from industrial installations. And what was actually emitted, so the actual numbers and what was emitted, so that the substances that were emitted. But the court really clarified that it's a concept that's far wider than that, and it includes so information on the actual or foreseeable emissions from substances that are released into the environment in the course of normal use. So this can be. In this case, it was talking about pesticides. It was talking about glyphosate, because obviously glyphosate is sprayed into the environment, and that's its intention. But I think that in the future, this this case law can really be interpreted to apply to a lot of other types of environmental information. So, for example, nanomaterials that are in cosmetics, which we wash off our face or which we spit into the sink and that are then emitted into our water systems, etc. There's quite a lot of potential to use this case law. And it's really information that allow us to understand the nature, the composition, the quantity, the date and place of the emissions, and on the consequences of those emissions on the environment. So Ivy touched on this case law a bit. So the big cases of November 2016, which gave the great principles on this, which you see in the bullet points, were applied just then in 2018. The judgments came out. Yeah. So first of all, the first case was one of the original cases in November 2016. It was a case by Greenpeace and PAN. They asked to have access to the studies that were, basically it was the report of Germany and the studies that were submitted by Monsanto in the procedure for authorising glyphosate as an active substance. And the General Court said they could have access to it. It went up to the Court of Justice, which gave the principles on what access to emissions actually is, but then sent it back to the General Court to actually apply the judgment to the facts of the case. And really surprisingly, the General Court, having kind of used the judgment, decided that the information was not about foreseeable emissions, because it was about then it becomes complicated. Because actually it was about the studies that were done on glyphosate. So that's the active substance glyphosate. Glyphosate is then not sprayed into the air just as glyphosate. It's put into a pesticide with lots of other substances as well, which make up the product. And so the court said that because that's the product in the end, it's a product containing glyphosate that's actually sprayed into the air, that the information on glyphosate itself, it wasn't foreseeable that would be admitted into the environment or relevant to what was actually in the end admitted into the environment. It was a very disappointing judgment, and I'll come back to it because it's disappointing for other reasons as well. But then, just a few months later, the General Court had another opportunity to apply the great November 2016 judgments on emissions into the environment, and they came to a kind of different conclusion, because this case also, as Pivy mentioned, was also about having access to the study information on glyphosate, and it was the long-term carcinogenic studies. And the General Court said that, well, we know that glyphosate is then put into a product and that it is sprayed into the environment. That is a reality. Glyphosate is emitted into the environment, and therefore the information on the studies comes under the definition of information on emissions into the environment. So two kind of very different applications of that judgment. Very briefly, I just want to touch on the specific rules that apply to environmental information on active dissemination. So Article 4 of regulation of the Aarhus regulation really has quite clear obligations. It says that the community institutions and bodies, they shall organise the environmental information which is relevant to their functions and which is held by them with a view to its active and systematic dissemination. And then the second sentence says, they shall make this information progressively available in electronic databases. This is also read often in conjunction with Articles 11 and 12 on active dissemination in Regulation 1049. I think that we've already mentioned that registers on environmental information is still a really big problem in institutions. There's still a lot of information that we simply isn't on the registers at all. And that we just simply don't know if the information exists. And that really means that it makes it very difficult to do access to documents requests that are very precise and which enable people handling them to very quickly identify the information that we want, because we have to make them in a very open way, because we just don't know what exists. So I think registers, they may not bring down the number of access to documents requests that people make, but they might really improve the quality of the access to documents requests. They might make them help to make them much more specific, which means that people handling those requests can do it in a much more efficient manner. So I'd really push for that. I have to say that it's true that we can't test this in the court. It's very difficult, but we have taken a couple of cases, brought a couple of complaints in the Ombudsman on this duty to actively disseminate information. And I have to say that I've been a bit disappointed with the Ombudsman's reaction to that. They've said that they can't make a finding of maladministration because the obligation in this article is just simply unclear. It says that they shall organise their information with a view to its active dissemination and that it shall make this environmental information progressively available. The word progressive, I mean, it means that some progress has to be happening, and we don't see that. And I think at the very least it means that the information that the institution has in front of them that has been requested and which they are agreeing to disclose should be made available on a public register. That's the very least that it means, but and unfortunately the Ombudsman hasn't gone there yet. Anyway, so that was all. Finally, just a few words on access to justice in respect of requests for environmental information. So this is a very clear right in the Aarhus Convention that that NGOs and members of the public need to be able to challenge refusals on access to justice and on access to information. And this is actually the only area that NGOs and individuals currently have access to the courts of the EU when we're protecting environmental interests and the public interest in general. In general, we just don't have access to the court, but on access to documents we do, because the decision is addressed to us, so we can go there. However, just now we're having a bit of a problem because in the access to information on emissions that I spoke about, where it was Greenpeace and PAN, two environmental organisations who had requested access to information on glyphosate studies. It went to the General Court, it went to the Court of Justice, it came back to the General Court, and at the end of all of that, they were the costs were awarded against them. Usually when it's the costs of the institution in court proceedings, that's not a big problem because the time of the institution's agents in arguing the cases, etc., has already been paid by our taxes, and so they don't charge us money for that. We only get charged their photocopying costs and their travel costs, etc. In this case, there were 6 interveners: CropLife EU, CropLife America, and 4 other big private interveners who all had their own teams of lawyers, and Greenpeace and PAN were awarded the costs, had to pay their costs. So in the Aarhus Convention there's a really clear provision that says that access to justice must not be prohibitively expensive for NGOs and individuals. And here we see that this is quite a big problem then in the EU. I have to say that within our organisation, this decision is affecting our strategic decisions on how we litigate, and that's quite a big problem. We don't know exactly what the implications of that cost award are yet. Actually, perhaps the Court of Justice will take Aarhus into account, but at the moment, when we don't know, it's causing a lot of problems in the NGO community. Secondly, I just want to point out the Aarhus Convention also says that in decisions that refuse access to documents, you have to say what the provisions are for what the options are for challenging that decision. And the institutions do that generally. There's just a few things that maybe they could do a little bit better, in that they say you can go to the Ombudsman or you can go to the court, and they don't make it clear that they are in practice mutually exclusive options. And a lot of NGOs or members or just individuals really aren't aware of that, so they look at it and they think, well, let's try the Ombudsman first, and then if that doesn't work, we'll try the court. And they don't realise that once they've gone to the Ombudsman, there's no more possibility to go to the courts at all. And obviously, the Ombudsman isn't actually recognised as access to justice under the Aarhus Convention because it isn't. Its decisions aren't legally binding. And then finally, I discovered just last year that are really what I think is quite a well-kept secret of the Ombudsman, and is that you have the right to request a review of the EU Ombudsman's decisions. I've never been notified of that on an Ombudsman's decision addressed to me. I found it by accident, actually, on the website, and it would be really useful, I think, if the NGO community in general were made aware of it. So it could be something that maybe you could just put into your decisions at the end. So that's all, and feel free to ask any questions that you might have.
Thank you very much. I noticed that this